All right. Hi, everyone. Hi. All right. So I'd like to, everyone, stop talking? Good. I'd like to start with a moment of silence for the loss of Justice Scalia. I'll speak about it in a moment, but just start for brief remembrance of Scalia. Okay, thank you. Before we begin, I'd like to say a few words about Justice Scalia. You've only been in this class now for a couple weeks, and you may have been exposed to a few of his opinions. But it's almost impossible for me to quantify for you how great of a loss this is to the law. And I'd like to focus on a few of Justice Scalia's greatest contributions to the law and explain how this impacted everything is that we do. So Justice Scalia's first great contribution to the law was something called textualism. This is the idea that when you're trying to figure out what law means, you look to the text and figure out what the text means. Now, this may seem obvious to you. Why? How else would you figure out what the statute means? But before Justice Scalia came on the Supreme Court, text wasn't that important. You would see opinions from the Supreme Court in the 1970s that would say, because the legislative history is not clear, we will turn to the text of the statute. Justice Scalia put a stop to that, dead halt. Lawyers would come to the Supreme Court and cite legislative history, say, I'm not interested, I won't cite it. In fact, even if there's a majority opinion that cited legislative history, he would dissent in that part of the opinion. It worked. Now, every justice starts with text. Maybe they'll go to legislative history afterwards, but he changed the norm. Justice Scalia's second major revolution in terms of constitutional law was what's known as originalism. We'll be discussing this at great length in the class. Originalism is the idea that you interpret a statute you interpret the Constitution based on how the words were originally understood. Now, he didn't invent the idea of looking to history, but he made it into an art form with a methodology of what's called original public meaning originalism. Before Justice Scalia came to the bench, living constitutionalism was the norm. The Constitution is a living tree and can be whatever you want it to be, whatever you get 5 votes for. And Justice Scalia said, no, that is not the job of a judge. And he instilled in generations upon generations of lawyers and law students the idea that you start with history. And whether or not originalism prevails in the long run, the crowning victory of originalism is a decision from 2008 called District of Columbia v. Heller. This was a decision trying to understand what the Second Amendment means. And although it was a 5-4 decision, it was divided. All 9 justices agreed that the way to answer this question of what the right to keep and bear arms means is to look to the original understanding of the Constitution. They disagreed on the answer, which is fine. But they all agreed that history is the right way. The third attribute of Justice Scalia's legacy that I want to instill in you, and I've already tried to instill in you, is try to separate the law and the policy. One of the hardest things for law students to do, and if I succeed in this, I will consider myself a good professor, is to say, you know what, I think that's a good policy. That's not constitutional. You know what, I think that's an awful policy, but it's constitutional. Already a couple of you have come to my class and spoken about these things. It's a hard choice to make, but it's something that I value very highly. And I'll give you a very good example of this. So at the 1984 Republican National Convention in Dallas, a guy by the name of Johnson had a protest. He burned an American flag, burned it. He was engaged in an act of defiance. He wanted to protest the man, protest the Republican Party, protest Ronald Reagan, whatever it is. Texas arrested him. They charged him with a crime, a flag desecration. Johnson's case went all the way to the Supreme Court. And the court, in a divided opinion, it wasn't 5-4, I think it was 7-2, but a divided opinion ruled in favor of Mr. Johnson. What did the court say? The First Amendment allows you to engage in expressive speech, and in this case, burning a flag, as awful as it is, as protected speech. Joining the majority opinion was Nino Scalia, right? Now, this is a story that I heard. I have no idea if it's true, but apparently the day after the decision. He's having breakfast with his wife, and his wife was very conservative. And his wife looks at the front page of the Washington Post and says, "Supreme Court upholds flag burning," and she starts humming the national anthem. And he says, "I don't need this shit." And he goes, "Well, I'm going to go to work." I've heard that story. It's probably true. We're close to it. But the Scalia would always tell the story saying, "Listen, that scruffy hippie should have gone to jail. But in my role as a judge, I have to separate myself from the law. Even though I think that guys are, awful human being for burning a flag, that's not my role." Another attribute of Justice Scalia that's often forgotten is he was one of the best friends of criminal defendants. The best friends. So the Sixth Amendment has something called a confrontation clause, which means you can confront your accuser. If you're charged with a crime and someone says, "I saw Blackman doing that," you can confront, say, "All right, you know what? I'm going to cross-examine you, and I'm going to try to challenge your rendition of the facts to see if, maybe you're lying," right? This is an essence. For decades, the Supreme Court basically ignored this clause. They allowed out-of-court evidence to be admitted so long as it was, quote, reliable. Reliable. You'll learn about this in evidence next semester. Scalia said, no. The Constitution says you have the right to confront your accuser. It means what it says, and it says what it means. And in 2006, in a case called Crawford v. Washington, Justice Scalia restored the confrontation clause to its original meaning and said, "You know what? Someone's accusing you of a crime. You go to court and you testify. We don't do this bogus submitted paper report. That's not how it flies." Scalia would often say he's the best friend of criminal defendants. These stories are relevant, and I tell you these stories to try to paint a picture of a complicated and indeed a brilliant man. Okay, no doubt Justice Scalia often was inconsistent. I've called him out on many times where he wasn't consistent with his past principles. But the only reason that we can say that Justice Scalia was not consistent with his principles was because he had principles to begin with. And the same cannot be said for a number of judges. Indeed, on the court, we can look no further than Justice Scalia's friendship with Justice Ginsburg as proof of how great his impact was. You could not pick two people who were more opposite on the political spectrum than Justice Ginsburg and Justice Scalia. Yet, as RBG wrote, Ruth Bader Ginsburg's RBG, as she wrote in her memorial, they were best buddies. They were best buddies. There's this awesome picture you can find online of the two of them riding an elephant in India. They traveled the world. They went to opera performances together. And I think they're proof that you can have people who disagree on the substance but respect each other. And one thing Justice Ginsburg always said about Scalia, even when he was in dissent, as he often was, his dissents made the majority opinion sharper and stronger. Because when you have to respond to a pit bull, you make your arguments more sound. And this is a beautiful lesson for us to learn. Having everyone around you who agrees with you is not very helpful at all. You become complacent, you become lazy, you become indifferent to different ideas. I will challenge every one of you, no matter what you think, to consider the opposite. Might be the first time you've ever been challenged in this fashion, which I relish in. And about Justice Scalia's dissents, I don't know if you've read any quite yet. Oh, you read Noel Canning. That was one of his most brilliant opinions ever, in my opinion. Justice Scalia often says dissents were not for his colleagues in the court. No. His dissents were for all of you. He said he wrote his dissents for law students so that they'll be put into casebooks, with his sincere hope that one day his dissents will be vindicated, that one day his dissents will be majority opinions. His dissents will live far longer than he did. We'll be reading them for years, unless casebook editors take them out, which I hope they don't. I'll still assign them. In fact, one casebook editor, won't name who he is, decided not to include Scalia's dissent in the same-sex marriage case. He thought it was too hurtful and harmful. Foolish decision. Scalia was speaking for a different time, and the points he raises need to be addressed. Okay. I want to close with an anecdote about Justice Scalia that was one of the first times that I met him. So one of the joys of going to law school in Washington, D.C. is you get to see the justices on a somewhat, frequent basis. And when I was a 3L, Justice Scalia released a book called Making the Case. It was a book with Brian Garner, who writes the Black's Law Dictionary. And Justice Scalia, in the span of 5 months, held like 6 books events, which I went to all of them, of course. And I went to the first book event, and I bought a copy of his book, and he signed it for me. I was like, "Thank you, Justice Scalia." And I went to the second event, and he signed it. I was like, "Okay, thank you, Justice Scalia." I was like, I don't really need a third copy of this book, but that's the only way you get to meet the famous person. So I was like, okay, let me try something else. So I'm waiting online, and I go up to the front. I was like, "Justice Scalia, would you sign my Constitution?" He's like, "Get away, no." He only wanted to sign a book. I'd already bought 2 copies of his book, but whatever. So then there's another event. I was like, "Justice Scalia, please, sign my Constitution." And he's like, "No, scram, get lost." So then I hatched an idea. I hatched a plan. Justice Thomas was coming to George Mason. One of my professors was a Thomas clerk, and he was coming to give a lecture at Mason. So, I wait online to talk to Thomas, and I say, "Hey, Justice Thomas, can you sign my Constitution?" He's like, "Oh, yeah, sure, why not?" So Thomas signs my Constitution. I knew Scalia was having an event a couple weeks later. So I again wait online. I wait online again. And I go, "Justice Scalia, would you please sign my Constitution?" He's like, "No, get lost." It's like, "But Justice Thomas signed it." He's like, "All right, give it to me." And you can see it after class, but I have to get this frame now. If you can see up close, it's Justice Thomas's and Scalia's signature on the same Constitution. And I have an entire photo album of my mementos. I didn't have time to prepare anything, but this is my office. You can, after class, if you like, you can look at it after class, and then here's my picture of Justice Thomas. I was a little younger and thinner at the time, but it happened to all of you. Don't worry. I have Alito also. I have a bunch of them in there. Yeah. This was actually this is just Alito. He used to have these. Ted Olson, who used to be a very prominent Federalist member, would hold these receptions at his pool house, and Alito was there chilling by the pool, which is kind of cool. Yeah, that's nice. So I have pictures of all. I think I have 6 of the 9 justices that I have pictures with, but I stopped trying. So now the loss of Justice Scalia is momentous. He held together so much constitutional law. It's very difficult to even think of the last 30 years of the United States Constitution without him. Even though he was often in dissent, his voice was usually the most clear. And we'll read a number of his decisions. I may even assign 1 or 2 more in memorial. Lucky you, right? But we will read a number of his decisions this year. And I think you will find that they're easy to read, they're understandable, and they often demand an answer which the majority opinion cannot give. Would anyone like to say anything about Justice Scalia before we begin? It's a very, very difficult topic for me. I was very distraught on Saturday when this happened, but it's very tough. Anyone want to say anything?
Question: what does that mean going forward, though? Do you have any thoughts on that?
Okay, so the short answer. The short answer is that we now have an 8-person court, and we may have an 8-person court for I don't know how long. This is not the first time the court's been shorthanded. In fact, I'm actually writing an article as we speak. I mean, not at this moment, but today, researching all the instances when the court was shorthanded. So, for example, I've mentioned Robert Jackson before, the guy who wrote the Youngstown Concurrence. He took a year off to go to Nuremberg to prosecute Nazis. The court had 8 justices for almost a year and change. They managed. There are other situations where justices died, resigned, and there were vacancies for pretty extended periods of time. Most of the cases before the court are not 5-4. I know that's what law students love to think, but probably 85% of the cases are decided not by a 5-4 margin. So this won't affect the overwhelming majority of the court's docket. There are this year likely maybe a half dozen cases that'll be 5-4, maybe 8 cases will be 5-4. And for those, now that they lost a 5th vote, the court has a couple options. So one option, which is not particularly attractive, is what's called a 4-4 tie, a 4-4 affirmance. And what a 4-4 vote does is it affirms the lower court judgment with no opinion. It simply says we will leave in place the lower court opinion with no new precedent being set. That doesn't resolve anything because the exact same issue can be brought back up and it'll go to the Supreme Court at some point in the future. What I think the more likely options, and this is what I'm writing about, is the better option is to actually re-argue the case and just hold it over till next year when there may be a full court. They don't need to argue it right away. They can even schedule for argument in, March or April of 2017 when there might be new justice in the court. The court doesn't need to finish everything by the end of June. I mean, that's their custom, but it doesn't need to. Now, concerning the immigration case, which we studied last week, and which I was so hopeful that Justice Scalia would be able to write for this case. Because in a 2012 decision called Arizona versus United States, he effectively, I was in the court when he delivered it, he accused the administration of not enforcing the law with the 2012 DACA, the Deferred Action for Child Arrivals. He accused them of it. His dissent basically was a blueprint of what the majority opinion could have looked like. No more. What's interesting about the immigration case is that the Solicitor General asked him to rush to hear it this term. Why? Well, depending what happens in 2016, whoever the next president is, very well may rescind DAPA. And then the case is mooted. The case has no purpose. So in one respect, the easiest way for the court to rule in this case is not to rule at all. We argue it next year and let it go away. Or they can issue a narrow 4-4, which have the effect of affirming the Fifth Circuit's injunction and keeping DAPA on hold so the next president can rescind it. Or if the case goes 5-3 or some other such configuration, they can actually reverse and rule in favor of the president. There are different options, and that case in particular is very, very tricky. I'll be writing something about it. Stay tuned. You'll see it soon. But this has taken us all by a surprise. It's taken us all for a loop. And there's much things to be thought out. Yes, ma'am.
So it sounds like what you said that either you are in agreement with Congress or the Senate.
Oh, I said nothing. I said nothing. I said in the event that a justice isn't confirmed until next year, then that's what we heard. I expressed no opinion on that. Other questions? Yes, ma'am. I'm so proud of you. At least one or two of you emailed me about that over the weekend. So I had a panic attack on Saturday. I had a panic attack because within 30 minutes of Scalia's, I was like, oh crap, they're in recess. I realized that immediately, like, uh-oh. And I went to the Senate calendar and I was counting days. I'm like, oh crap. So I emailed some people, and anyway, that issue was taken care of. But the president said he won't do it, and that's good enough for now. But had he wanted to, there actually was just 10 days. And indeed, if you remember Noel Canning, this was actually the most creepy experience of the entire week for me. I was rereading Noel Canning. I often do. And Justice Scalia's dissent, if you recall, or his concurring opinion, says that period between 3 and 10 days, right? It's that period we're not sure what happens. And the majority opinion says, well, between 3 and 10 days is presumptively bad unless there's some sort of emergency. Well, is having a short Supreme Court the sort of emergency that would trigger Justice Breyer's exception? I had this chilling thing like Scalia was talking to me from beyond the grave. It was really surreal. It was weird. But I sent some emails, and within an hour or two, I was affirmed that the president would not be doing that. So I took care of that. But it occurred to me very quickly, and I freaked out. So yeah, a recess appointment. I mean, it's been done. President Eisenhower made a recess appointment of William Brennan and Chief Justice Earl Warren. So there is precedent for that, and which I was well aware of. Yeah.
I'm not sure if this is true, but I read that like 4 ties.
It affirms the appellate court. It sets no precedent. So in theory, the exact same case we brought in a different circuit. That's why it's unsatisfying. So to give you an example, the Little Sisters of the Poor case, the contraceptive mandate case, there's currently a split among the circuits. 7 courts of appeals ruled that the contraceptive mandate accommodation is lawful. 1 court ruled that it's not. So if there's an affirmance, what happens? Basically, you have religious liberty in like 6 states, and the other ones you don't. It's a really weird situation, which is why I think the best case scenario is not to do a 4-4, but simply hold the case over. But yeah, I don't get to make these calls. Yeah.
So do you think that a primary motivator for President Obama not to use the recess appointment is just the fact that Scalia just died? I mean, do you think that the vacancy had occurred a month ago or a year ago or something?
I mean, with respect, I think this took everyone by serious surprise. I think it took everyone by such surprise that people said dumb things all around and they didn't know what they were doing. Give it a couple of days, the message will start to solidify. But this took everyone by such surprise. I mean, I made a number of phone calls over the weekend to people to tell them about this, and there were tears, right? So this is a big deal, and people were asked on the spot to say things, but they probably didn't really know what they were doing. But yeah, it was very moving. Yes.
But he does only get like what, 10 months.
It would be till January 2017. That's all. It would only last for a bit, so it really wouldn't have done much good. It would have expired by the middle of next term. Any other questions? Yeah.
I know it's looking a long way out. Are there right now? There any is there somebody like everybody's talking about waiting in the wings? Is there a presumptive nominee?
Oh, I don't know such things. It's all idle chatter. Everything you read is idle chatter. Until the nomination's made, it's all speculation. It's all rumor. I would not put much weight in any rumors you read. Any other questions? Yes, sir.
I just was curious. Do you think Scalia would be kind of disturbed that his replacement has this much impact and that the role of this court has become this polarizing?
I don't know, you got to ask him. You should ask him. I was joking with a friend over the weekend that somewhere right now, Scalia and James Madison are having an argument over what the Constitution means, and he will argue to the death, or as opposed to beyond, about that seems right. But I don't know. Any other questions? Yeah.
I don't want you to answer this with your own personal opinion, because I know you wouldn't do that. But just in general, do you think that the Senate, if Obama does, well, he's going to nominate someone. If he nominates someone that's a moderate, do you think that the Senate is more likely to just go ahead and affirm that?
Well, I'd respond to it this way. The idea of a moderate is something that's been bandied about. It's often said that Justice Breyer is a moderate, as opposed to Justice Ginsburg, who's a liberal. Compare their votes. They're pretty similar. I mean, they may diverge in a couple cases here and there, but there's not much of a difference. So, the difference between Justice Sotomayor and Justice, Breyer is, there's a couple cases they'll disagree, but not much. So the idea that a moderate would be some sort of a compromise, jurisprudentially, I don't think that gets you very far.
But do you think that the Senate is more likely to confirm a moderate, or actually push all the way through to the next?
For the reason I just said, I don't think they'll believe a moderate, in fact, is moderate.
Okay.
Right? I mean, Justice Breyer was appointed as a moderate, and his vote and Justice Ginsburg is off. They're identical, but in the big cases, they're lined up. In fact, last year, Justice Ginsburg made a point of saying how the 4-vote block didn't break once. She made a point of stressing this. How in every single dissent, the 4-vote block of Breyer, Kagan, Sotomayor, and Ginsburg held strong. She made a point of stressing this on several occasions. So, whatever. Let me put it this way. So, everyone take out your constitutions. Turn to Article 2, Section 2. I wasn't planning on doing this, but I may as well. I'm actually going to tie this into Federalist 10 in a minute, which is actually perfect. Page 30. Okay. Second paragraph. The president shall have the power. Okay. And then it says ... He shall nominate by and with the advice of the Senate, judges of the Supreme Court. Notice it doesn't say justices, it says judges, but anyway, it's a good point. So the president shall nominate. The president shall nominate. That means he must, right? He has a constitutional imperative, a constitutional duty to appoint someone to the court. There's no ifs, ands, or buts about that. The Senate, with the advice and consent. Does the Senate have any constitutional duty to give its advice and consent? No. Does the Senate have any duty to vote? No. Does the Senate have any duty to hold a hearing? No. The Senate can set its own rules and do whatever it wishes. Indeed, the entire idea of advice and consent comes from the Massachusetts Privy Council, which was in the Constitution of Massachusetts from 1780, drafted by John Adams. And under the Privy Council mode, the committee would say, we like this guy, we don't like this guy now, we want to leave the seat empty. Right? We want to leave the seat empty. So it's emphatically the province of the executive to make a nomination. Constitutionally, the Senate can do whatever it wishes. Now, someone say, well, this is political, right? This is a political process. Well, yeah, the framers made this a political process. There is no check if the president appoints an ambassador, or the president appoints a judge, or the president appoints whatever, and the Senate takes no vote. That's it, right? There's no remedy. The only remedy is political. And the president can use his bully pulpit to shame people who don't vote, to force people to take a vote, and do whatever he wishes. We have an election coming up, this community election. But constitutionally, the Senate has no obligation to do anything whatsoever. None. Zilch. I mean, zero. And there were quite a number of senators, in recent years, who have said there should be no vote. John Roberts was filibustered. Sam Alito was filibustered. Dozens of Bush nominations were filibustered. Bork was not filibustered. He was actually voted down. So constitutionally, there's no duty to vote. What will happen? I have no insights. I know nothing more than what you know. But constitutionally, there's no danger. But okay, last question. I'll go to Federalist number 10.
So could the Senate essentially get rid of the Supreme Court then in that case because they wouldn't ever have to?
Oh, what a good question. So the Supreme Court is created by the Constitution, right? What happens if the Senate confirms no judges? Is that your question?
Yeah.
So what's interesting is nowhere in the Constitution does it say how many judges have been in the Supreme Court. The only judge mentioned in the Supreme Court is one, the Chief Justice. The Chief Justice must exist to preside at an impeachment trial of the president. So I've actually thought about this before. I think the Senate would only have an obligation to confirm a Chief Justice, and that's it. Not that you care about that, but basically that's the only one that required. By statute, Congress could drop the Supreme Court to one justice. And as long as he's confirmed, the Constitution is not violated. It wouldn't be very effective. I mean, the court, for example, Marbury versus Madison, if I remember this correctly, I think there were 3 or 4 justices in that opinion. Right? Halton, the case we have in the notes, I think there were 3 justices. Period during the Civil War, there were actually 10 justices. As we'll discuss later in class, Franklin Roosevelt wants to appoint another 6 justices, right? There's nothing saying the number of justices in the Constitution. It can be modified. But that's an interesting question. If they appointed 0 justices, I think that would probably that would probably be unconstitutional.
But who would determine that? No justices.
Well, doesn't the Senate have a duty unto itself to judge constitutionality of statutes? Don't the people have the power to vote people out of office for misbehaving? Ah. See, not every legal wrong has a judicial check, which is something I want to drill into your heads, right? If Congress does something stupid, people can throw them out of office. That's politics. That's how it works. So maybe the Supreme Court will be empty for 2 years, and then you appoint a new Congress, and they appoint 9 new justices. Right? You don't need a judicial declaration to say something's unconstitutional. Every government officer in the United States takes an oath to the Constitution. Everyone, top to bottom. Your dog catcher, your mailman, every single one, right? And they have their own independent duty to judge what's constitutional. So hopefully, if members of Congress were adhering to the oath, they would not try and close the Supreme Court. I suppose they could. Franklin Roosevelt tried to basically render it moot by appointing 6 new justices. Didn't work. So there's been a long-standing history of using the Supreme Court for various political purposes. It's not something to be necessarily proud of, but this ain't new. All right, any other questions? I promise I'll tie this Federalist 10. So Federalist 10, after Federalist 51 is probably my favorite. I haven't ranked them all the way, but 10, 51, and 78 are up there. And in Federalist number 10, James Madison right now is having a vigorous dispute with Scalia. In Federalist number 10, Madison is faced with the dilemma. How can you have a democracy over a large area? This is the dilemma. So you think about, we just had a New Hampshire primary, right? If you have a small town with 100 people, you can have a town council meeting every week and have the people vote on every issue that comes before the town. And if there are 100 people, maybe 50 will come to the meeting, whatever. You still have a majority of the populace who shows up at these meetings, right? Small democracies have worked in Greece and elsewhere. But the United States had a very unique structure. You had small towns, and you had these things called states, which are collections of small towns. And then after the Articles of Confederation, you had this thing called a confederation, which was a league of friendship among these states. How can you make democracy work, to borrow Justice Breyer's title of his book? How can you make democracy work where you have a democracy spread out over such a large distance with so many different kinds of people? Some merchants, some trading, some farmers, some industrialists, some bankers, every walk of life. How do you get all these people to agree to anything? And I think, and I actually hope, our lesson from today will help shed light on the question that Natalie asked before that I dodged. How is it possible to get everyone to get along and sing Kumbaya? Right? Is it possible? I have no idea. Where did I finish last time? Anyone remember? No one raised their hand. I'll call on someone. Oh, I love it. Okay. All right, Ryan, you're up. Did I call on you last time?
Yeah, I think so. I was like, I think our row was like one.
We were one of the last ones to finish, like Brian.
Okay, did I call on you? I call on you guys?
Yeah.
Right there. Okay. Larry, up. I don't care if I call on you.
Okay.
Go for it. Larry, up. Is it possible, in the words of James Madison, to make everyone get along, to make everyone think the same thing, to make everyone have the same thoughts? Is that possible? Why is that not possible?
Because it's just never going to happen.
Why?
There's too many dissenting opinions.
What do we call those groups with opinions?
I think you called them factions.
Factions! What's a faction, Lara?
Basically a group that shares an opinion.
Yeah. Madison writes, we have this problem, right? We have this problem of factions. We have different groups that want different things. Just today, as we did 200 years ago. Different people with different interests want different things. Okay? Because of these factions, we're going to have conflicts over how to accomplish anything. So imagine if you're in a small town hall meeting, say 100 people in the town, and some guy is very popular and gets 60 of his best friends to pass a law that says, I don't know, all debt is eliminated, right? All loans are gone. You don't have to pay any of your debt anymore, right? Selling that sort of hogwash. So, Taylor, if you're in a small town with 60 votes, and it's only 100 people in the town, and this one demagogue is saying, I'll cancel all loans and debts, can you stop it? No. Why not?
Because you don't have power to vote.
Right. So the reason why I beat up so much on Justice Breyer for his promotion of democracy is that we don't have one. The framers of the Constitution were very distrustful of democracy. They feared democracy. Why? Because a single demagogue can pull together his friends and achieve some very, very awful legislation. Right? They were afraid of democracy. They don't like it. So we have this idea of factions, right, where this is instilled in each of us. And Madison wonders, as a thought experiment, is it possible to eliminate the causes of faction, right? Can we make, Dan, can we make everyone think alike? Can we make everyone just agree on the same thing?
No.
Why not, Dan?
People's needs and wants are different. People's inclinations are
Yes.
different. Affiliations.
Exactly, right? Madison, long before Marx, was writing that due to differences in intellect, ability, stature, property, people will have different interests. Farmers will have one set of interests. Bankers have a different set of interests. Industrialists have another. Traders. Every group is rationally self-interested. We're all rationally self-interested. We're all selfish, which is fine. There's nothing wrong with that, right? We all think out for number uno, right? Even if you like doing charity, you do it because it makes you feel good, which is selfishness, right? We all do things. I'm serious. You never thought of it that way, but even if you like doing charity, it makes you feel good. We're all rationally self-interested, and there's nothing wrong with that. Selfishness does not mean you're apathetic or you don't care. You do things for self-interest. But even worse, Madison recognizes that the only way to make everyone think alike is to destroy the liberty that allows them to think. And if you ever studied a communist nation like North Korea or China, the reason why they have propaganda is to make everyone think alike. They are trying to do that which James Madison said could not be done. Through the use of propaganda, they're trying to make everyone think alike, worship the dear, the dear leader, Kim Jong-un, right? To believe whatever the propaganda of the day is. That's why they're propaganda. They're trying to shape the minds and break apart what Madison said was impossible. But Jimmy Boy had it right 200 years ago. You can't do that. It's impossible, right? So you can't make everyone think alike unless you destroy the liberty, the freedom that allows them to think alike. Madison writes that this factionalism is inherent in man. I'm sure if I polled this class on a number of topics, you only have about 8 of you here, different factions would form on this, on that, on this view, whatever, which is beautiful, right? Because what did I say at the outset of the class about Justice Scalia's dissents, right? Travis, why is it so important that you have a majority opinion and the dissent is agreeing? Why is that so critical? What did Justice Scalia's role play? And I'm going to tie it together really well.
It makes the majority sharper.
Yes. Madison's insight is this. Having competing factions is not bad. James Madison turned lemons into lemonade. He said, listen, we have this problem of factions, all these different groups arguing across a wide expanse of our country. Instead of making that a problem, let's make the solution. Let them butt up against each other. To borrow from Federalist number 51, ambition must be made to counteract ambition. And when ambition is checking up against ambition, when faction is checking up against faction, only the strongest ideas will emerge from that fracas. When the factions are fighting each other tooth and nail, and there are going to be so many factions nationwide, only the most strongest, the ideas that have the greatest appeal, will emerge from that altercation, right? When you have a Justice Ginsburg majority opinion and a Nino dissent, you can be sure that whatever the rule of law is sharper than if Nino was not there. Nino was short for Antonin. If Justice Scalia was not there. So in respect to Justice Scalia, his pit bull nature proved Madison's insight. In Federalist number 10, if you have one group of traders, one group of bankers, one group of farmers, they're all competing in Congress. They're all saying they're members to Congress, and they have to fight and drag. Okay? And eventually, the strongest solution emerges from that fracas. But the flip side to that is, and this is to answer Natalie's question directly, Robin, the flip side to that is, what if they can't agree? What happens if the factions can't agree?
Like you said, they just express their opinions and they either find a way to compromise or they...
Let's say they can't find a way to compromise. They're so diametrically opposed. What happens?
And they need to find a way to...
They can't find a way. I appreciate you trying to dodge my question. You're very compromising. I appreciate that, but they cannot find a way to compromise. What happens? What happens to the pending nomination or the bill that's been proposed? What happens to it? Dies. Goes nowhere. So in many respects, and I think I discussed with Noel Canning, with the idea of gridlock, right? Gridlock is often sold in this country as this evil thing that, Congress is being evil. But if you take a step back, the members of Congress represent their districts. And they, for the most part, do what their districts want. And if half the districts say yes and half the districts say no, then the bill doesn't pass. The judge doesn't get confirmed. The treaty doesn't get ratified. This is not a bug, as Justice Scalia so presciently described. It is a feature of our constitutional framework. It's a feature of it, right? The fact that there's gridlock means that the thing's working, that the parties are not supposed to push stuff through unless it's following the procedures. So the Constitution says advise and consent to the Senate. Well, unless you have 51 votes, then you don't have the advice and consent to the Senate. Politically, that might be a bad decision, but that's a political problem. And more so when people attack the members of Congress for perhaps voting or not voting one way, you should recall what their constituents are telling them as well. It's not a one-sided affair. And indeed, if a senator is up for re-election and does something their constituents don't like, you can throw the bum out. We have an election in, 11 months? 10 months, whatever it is. 9 months. Oh, man, we're less than 9 months. Oh, it's going to be one hell of a year. So the insight from Madison, presciently, I suppose, I wasn't planning this, but your questions led to it, revealed that factions cannot be eliminated. And indeed, factions are what prevent any one group from taking over. Now, to Madison's defense, the idea of a political party in 1789 was not known. George Washington did not really have a political party. There were groups, but they were pretty united on a number of issues. What's distinctive about the American experience today is that the division is not along interests, right? It's not along bankers and farmers and industrialists. It's among Republican and Democrats. So instead of having many factions, for the most part, we have two. You have, within each group its own wings and stuff. But the difference is you have effectively two factions that can dominate the political process. And the possibility of anything going past this or gridlock decreases. I told you about the partyism, right? With the dating of the children. To tell you this? So every year since like 1950s, surveys are asking, would you be okay with your child marrying somebody opposite race? Did I tell you this? Yeah. Okay, right. So remember the nub of the story was people are okay now with interracial marriage. Awesome. Okay. People are not okay with interparty marriage. And I think you need to reflect upon that when you look at what's happening in Washington. It's not simply these congressmen are being evil and ignoring their constituents. They're representative of their constituents. They are. And until that changes, Congress will not change. Okay? So anyone have any questions on Federalist 10, how Madison effectively describes in a large republic, you can use all these competing interests, competing factions to check against each other and ensure you don't have any sort of a demagogue trying to subvert the republic, right? The idea of a Republican form of government is that you have this representation that's divided. So we had the Senate. How was the Senate selected originally? By the state legislatures. You have the House, voted directly by the people. You have the president, voted by the Electoral College, based on the state's number of representatives and senators. There were all these indirect checks. The framers did not trust democracy. It was not a thing they liked very much. And Madison says, the happy constitution, right? I love that quote. This happy constitution is we use these pre-existing states as a check against each other. Right? We read in Federalist 51, my favorite quote, if men were angels, no government would be necessary. Nino may be an angel right now, but we are not. And we need no government. Yeah, actually, I think I wrote a blog post that said, Justice Scalia, as always, needs no government. Oh, nice, right? 5 people got that. Okay. Any questions on Federalist 51? Sorry, Federalist 10. Anything? Okay. What's funny? Yes, go ahead, please. Yes, sir. Why what? We don't have a popular vote for president. We absolutely don't. Yeah, but it doesn't count.
Yeah, I know it doesn't count, so why is it still like?
Well, you need to know how many people vote in each state to award the electoral votes. So it's actually happened in the past, not so much anymore, that say a candidate would win a state's electoral votes. And then the member of the electoral college says, you know what, that guy's insane. I'm not voting. We'll vote for someone else. It was meant as a check on the people voting for someone stupid. It doesn't really work that way anymore. But it's conceivable that an electoral vote may actually change the election. He decides, I'm not voting for this person. And that's entirely within his discretion. Yeah, but you can win the popular vote with a presidential election. People say, oh, that's evil. I mean, that's the system we have. I mean, that's the structure we have. You can change it and the Constitution, but the popular vote does not determine the outcome of the election. Other questions? Yes, sir.
So, sorry, this is more related to that question we're talking about now.
Yeah, sure.
So I understand why the electoral college is there to begin with, why it was put in there, but since the electors are decided by a partisan body nowadays, since there really is only two options, since they no longer would vote for anyone other than their party, or else they wouldn't get their job back the next time around, or they wouldn't be put in there to begin with, because they're only partisan people making those decisions. What's the point now? I mean, why? I know a lot of people advocate for.
I mean, there are reforms to abolish electoral college, and if you get 3/4 of the states to do that, then that's fine. What's interesting, though, is you actually don't need an amendment. A state can actually decide to award its electoral votes however it wants, and a number of states have signed a compact which says if a certain number of states agree to this, we will award our state's electoral colleges to whoever wins a popular vote. I think New York is either has signed it or is on the verge of signing it. So they'll effectively say, it doesn't matter how our own citizens vote, we will give our votes in the states whoever wins the popular vote. I mean, states can award their electoral votes however they wish, but you would need to change some stuff first. Other questions on Federalist 10? Yes, sir.
Like, does this link into like what Madison talked about with 3 election cycles that you need to win 2 out of 3?
Explain.
Like, so I have a faction, and my faction, like, party, whatever the party name is, like, you get a bunch of representation in the House or the Senate for both. Right? And let's say my faction survives 2 out of 3 election cycles, but then on the 3rd election cycle, the 3rd election in the cycle, there's a statute up for passing, and my representatives are against it, and I voted in all 3 election cycles, and so now I'm being held accountable for a vote that I disagree with, and I'm a member of that faction.
That's fine, and you can vote them out next time, and they can repeal the statute.
So I can just be upset until the next election.
Yeah, and then they can repeal the new statute, right?
Okay.
Statutes are not set in stone. Indeed, one of the few things that is set in stone is Supreme Court justice. You can undo a statute. You can't undo its lifetime appointment. Other questions? Okay. So let's go backwards. Let's go back to federalism. I took set of order because it was a nice segue. So the unit we're beginning now discusses the powers of Congress. We started off in the very first week with Article 1, did Article 2 for the executive, and we do Article 3 for Congress. We're returning now for the next couple weeks to the powers of Congress. Oh, by the way, I don't want to talk about the midterm much, but I got all your papers. I will be grading them in due course. So you don't have to ask me about them, but I will be grading them in due course. Okay. Federalism. Okay. Where's that to? Okay. Katie, tell me, what is federalism? What does federalism mean to you? Right? You look at talk shows, right? What's that?
So you like both?
No. Dr. Phil, maybe, I don't know.
I guess it's just like whatever protects the people. It's like liberty and
Well, that might be a consequence of federalism, but what is federalism itself?
just like powers and everything that people put into
You're too vague. Who's that? That's Sarah. Sarah, how would you define federalism? You trailed off at the end.
Oh, from the people.
Something that separates a state from the people?
Right.
What do you mean?
Well, to be able to protect, like Katie was saying, the liberty.
Well, I mean that you're right. That's a consequence. But is that Ashley? Ashley V. Ashley, what is federalism? No. That's why you do it at home.
It's just something that separates the branches and the different levels of government.
Okay, good. So separation, right? So okay, we're getting there, right? So what Ashley said was that federalism is something that separates the different branches of government. So right, so there really are two species of federalism. What you described is what's called horizontal federalism. Imagine we have our three branches of government. You have the Congress, you have the courts, and you have the executive, right? Horizontal federalism refers to the separation of powers between them, right? Between the three branches of the federal government. Right? Horizontal federalism refers to the three branches of government, the separation between them. Ashley C. Can you give me an example of what a separation of power is between the executive and the legislative branch? Give me an example. Yeah, what's an example of a check and balance that we've discussed between the executive and legislative power? Yes, beautiful, perfect. That's exactly what we led up our discussion today, right? The president appoints the judge, and the Senate confirms the judge. The president negotiates a treaty, the Senate ratifies the treaty. Right, good. Luis S., give me another example of a check between the Senate, between the Congress and the president. Good, give me an example. Right, so the House and Representatives and the Senate vote on a bill, and then it's up to the president to sign it. And then Luis finished it up. After the president signed it, what duty does the president have? To faithfully execute the law. Exactly right. After the president signs it, the Constitution gives him a duty to faithfully execute the law. So there are many checks, right? Say the president wants a bill. Say he wants a budget passed, give him all of this money, right? To buy all these tanks and aircraft carriers and whatever else he wants, right? And the Senate says, go take a hike. I'm not giving you that money. The president can't spend a nickel without Congress's permission, not a nickel, right? You know actually a penny is worth less than 1 cent? It's awful. Due to inflation, a penny is actually worth less than 1 cent. They should abolish the currency altogether. Most countries have actually eliminated the 1 cent piece. They just round up the change, so whatever the next nickel is. But it's actually, they actually lose money printing the penny. But yeah, so you have these checks, right? Rebecca, you want to think of maybe another example of a check and balance between the Congress and the president? We discussed the confirmation of judges. We discussed passing bills. Want to think of something else? Oh, right. So who has the power over foreign affairs? Yeah, it's shared, right? That was Zivotofsky. So can the president do whatever he wants with foreign affairs and make laws by himself for foreign affairs? It's shared, right? That was a lesson of Zivotofsky. You have some exclusive powers, you have some shared powers. So the Constitution erects these separations, these checks between the executive and Congress, right? Let's go back up top to, is that Jacob? Okay, so now this is the question what Katie and Sarah were answering before. Why does our separation of powers exist? Why does the Constitution separate the powers between the executive and the legislative branch? Why? Make sure it's not one branch getting too much. Good. Because what is the consequence, Jacob, of one branch getting too much power? Oh, there's an expression, yeah. What happens if one branch accumulates all this authority? What would you call it? A tyranny, yes. Yes, the Federalist said the accumulation of all powers, legislative, executive, and judicial in one hand, is the very definition of tyranny. Exactly right, Jacob. And then, so Katie, you want to answer again? Why do we have federalism? Good, and I'll also come back to you. How Sarah does federalism protect liberty? You guys are exactly right. It was 2 minutes early. How does the separation of powers protect their rights? Yeah. No, you gave the right answer. That's the how now. Think of Federalist number 10. Think of Federalist number 10 what we just discussed. How does separating these factions, right, protect liberty, Sarah? How? This is the insight that most law students will never actually understand. They just breeze by. Yeah, separation of powers is liberty. How? Catherine D. What role in terms of factions? Did you flip? No, am I right? All right. Okay, Catherine D. What role, right, does the separation of powers play in protecting legal freedom? Try and work Federalist 10 for your answer.
I guess it limits one faction's ambition over the other.
Good. What do you mean it limits one faction's ambition, right? What do you mean?
I guess by not letting one get out of control.
Exactly. So Catherine's E now. Oh, you're not DE. That works. Catherine E. What happens to say the House of Representatives is dominated by farmers, right? People from farming country, and the Senate is dominated by people from, you know, business industrialists, right? You got these factions, right? You got the farmers in Dell, right? And you have the bankers, right? EAO. How do they resolve that? What do they do? What can those two factions then accomplish? Can they pursue their own special interests?
Well, I mean, I feel like that's kind of the point, like we were talking about earlier, it's not a flag in a constitution, it's just part of.
You're exactly right. Answer the question. What will come out of a House dominated by farmers and a Senate dominated by industrials? What kind of legislation will come out?
Not a lot.
Well, not a lot, but more precisely, what kind of things can make it out? What kind of issues will make it out? You're on the right, you're really close. What kind of issues can make out of a House when there are these two divided parties?
Right, only the like most powerful party.
Yes. Think of the Ginsburg majority and the Scalia dissent. Only the strongest arguments prevail. This is Madison's insight, right? When you have these divided factions, only the positions that appeal to the most people, that have the most consensus authority, emerge from that fracas. When ambition is checking ambition, only the most widely shared beliefs will emerge. So there won't be any special interest farm legislation, because there won't be enough votes for that. And there won't be any special interest banking regulation, because there won't be enough interest for that. But general laws which appeal to, you know, what's in the middle, I suppose, that is what emerges from the altercation of when the factions check each other. That is the insight of why we have this horizontal separation of powers, right? The executive depends on the legislative, and the legislative depends on the executive, neither alone. A demagogue president can't go invade whatever country he wants. Why? He needs to have a declaration of war. Congress needs to fund his armies every 2 years. Can't do whatever he wants, right? But on the flip side, and this is something that's actually relevant, well, the president has lots of duties to execute stuff. Congress has no duty to pass any laws. They have none. Congress has no duty to ratify treaties. They have none. Congress has no duty to declare war. Congress has no duty to confirm judges. None. So really, the most dangerous branch by far is Congress. If the courts are the least dangerous branch, by far Congress is has the most dangerous power, effectively, to use your example, not confirming any judges and shutting down the Supreme Court. But they're also the most accountable, because there are many, many members held for election every year, and it's a populace that keeps them honest. So that is how the horizontal separation of powers work. In order to protect freedom, they divide the power among the different factions, which then check each other. This gridlock, as she says, is not a bug, but a feature of the Constitution. And the way the two houses are structured next to the presidency embodies that sort of conflict. It's a healthy consequence of our government working. Any questions on the horizontal aspect? We'll come back to this many, many times. Any questions before I move on? Yeah, it was actually a fairly good day for this topic. Good day. Okay, the second time. Oh, is that a hand? Are you twinkling your?
Well, so isn't original federalism also related to the separation of powers among the states, not just the branches within the national government?
So, what's vertical federalism?
Versus federalism would be the national versus the state.
Okay, good. You can have horizontal federalism. For example, there's a Texas House, there's a Texas Senate, and there's a governor, right? That's horizontal, but I'm not discussing state federalism. It's actually a very different story. State constitutional government, I encourage you to take it. It's an interesting class, but far beyond the scope of what I have time for. So vertical federalism, as he just said, is a separation between the state and the federal governments. Okay? Vertical federalism is a separation between the state and the federal government. Now, our governmental structure is as much a product of design as historical happenstance. What do I mean by that? In 1776, when the United States declared their independence, there were already in existence these 13 things called colonies. Became states. These existed before we had a republic. And maybe if we were drawing from a blank slate, right, we would never have created states in the first place. Maybe we would, maybe we wouldn't. But the framers of the Constitution were confronted with the reality. There were 13 states, and they had very different interests. The southern states were agrarian, favored slavery. The northern states were industrialists and traders. They, were either ambivalent or opposed slavery. And then you have the middle Atlantic states that are a little bit of both. There were very different interests. So again, the genius of the Constitution, the genius, is they turned lemons into lemonade. They looked at these divergent states not as something that needs to be stifled, but as something that can form the basis of a republic. So not only were powers divided between the three branches of government, powers were also divided between Congress and the states. Okay. Let's see, that's, is that Zach? Zach, tell me, please. Describe for me the balance of power in our Constitution between the state government and the federal government, please. Describe the balance of power in terms of how the Constitution is drafted. Oh, sure. No, there's a supremacy clause, right? But which powers does the federal government have versus which powers does the state government have? I'll start easier. What powers does what power does the federal government have in the Constitution? We discussed this before. Which powers does the federal government have? Does Congress have?
Start on it through the Constitution.
Good. Which article?
Article 2.
No. Which provision, you got to know this called, which provision of the Constitution gives Congress its powers?
Article 1.
Section 8. Good. Article 1, Section 8. Article 1, Section 8 lists all the powers of the Constitution. Shelby, I mean, there are a bunch, like there are 25 of them, right? Can Congress do whatever it wants? Can they do whatever they want?
Yeah, they have enumerated powers.
Yes. Magic words. Congress has enumerated powers. Magic words. Article 1, Section 8. Thank you, Shelby. Congress only has those powers which are given to them in the Constitution, nothing more. Now, we discussed in McCullough v. Maryland, under the necessary and proper clause, it's a pretty wide power. But we still say, and it's still good law, even with Justice Scalia not here, it's still good law, that we have a government of enumerated powers, only that which is in Article 1, Section 8, and as well the 14th Amendment, a few other places, Congress can do. Michelle, does the Constitution define what powers the state governments have? No. Where do the state governments get their power from? Say it again. Yes. Beautiful. That is the 10th Amendment, and stated backwards, but just as right. No, you're right. The 10th Amendment, right? And I have it up here with a little bit of editing. The powers not delegated in Section 8, okay? The powers not delegated to Congress in Section 8 of Article 1, nor prohibited to the states in Article 1, Section 10. For example, they can't do bills of attainder and other things, right? So the powers not given to Congress in Section 8, nor prohibited to the states in Section 10, are reserved to the states or to the people. So Michelle's exactly right, just to say a little bit differently, whatever power is not given to the feds, the states retain. The states retain the entirety of the power. Okay? Cindy, what's that power called that the states retain? What's a state's power to make laws called? We've discussed this before. Anyone know? Bingo, police power. I'll come back to Cindy in a second. The police power is the powers reserved to the state. While Congress is a government of enumerated powers, they can only do that which is delegated. The states have a police power of broad authority. States can do anything they want unless it's prohibited by the Constitution. Let me say that again. Congress can only do that which is authorized by the Constitution. The states can do anything they want unless it's prohibited by the Constitution. Everyone see that? Congress can do whatever they want so long as the power is given by the Constitution. The states can do anything they want so long as the Constitution does not prohibit it. These are very vast differences in authority. Okay? Cindy, I'll come back to you. Where did the states get this police power from? Where did the states get this vast police power from? Where do you think the states in 1776, when they became independent, got this vast police power from? It's not in your reading. It's not in your book. I'm giving you a lot of hints. Where do they get this police power from? In 1776, upon declaring independence, where did they get it from? There's a reference in Zivotofsky also last week. No. Natalie? Well, where did the power come from? They just declared independence. Where did the power come from? And where did it come from? Not from the document. Where did this power come from? Did the people in the colonies have this power before 1776? Before 1776, the people in the colonies have this power. Had it. Yes. Upon becoming independent states, the states assumed the police power from the King of England. The states assumed the police power. The power must exist somewhere. Sovereignty does not disappear. You go from one sovereign to another. And the states accepted that power and sovereignty. The states accepted the full scope of the king's authority. You recall the Declaration said we have the power to make war, conduct treaties, do commerce. They accepted the king's powers, right? So the states had this massive amount of power. But then, as at Whitney, we went to the Articles of Confederation. What happened to the states' power after the Articles of Confederation? What did the Articles of Confederation do? I had you read it for a reason, I promise. What did the Articles do, Natalie? Whitney. She got scared for a second. Expressly stated what? Whose powers? And who else? The new government, right? The central government. So Whitney, where did this new central government get their power from? Who joined the Articles of Confederation? Who are the members of this confederation? So where did the central government get their power from? Not the people. I'm asking again, who joined the Articles of Confederation? So where did the central government get their power from? The state. Thank you, ma'am. When the states joined this League of Friendship, known as the Articles of Confederation, they gave up some of their power. They gave up some quantity of their power to this new central government. But whatever they did not give up, they retained. The states gave up very small powers about negotiating treaties and war. You know, we read through it on day number 1. They gave up this power to this new central government. I want to get that. Nick, fast forward a couple years. The new Constitution is ratified. What happened to the state's powers when the Constitution was ratified? What happened to the quantity of power? Diminished. Where did it go? Yes, sir. I'm about to blow your minds, but it'll make sense. Every single item in Article 1, Section 8, Nick, finish it up. Every single item in Article 1, Section 8, where did Congress get that power from to do it? Exactly. The states gave Congress the power to regulate commerce among the several nations. The states gave Congress the power to punish piracies, our favorite. The states gave Congress the power to establish postal routes. The states gave Congress the power to lay and collect taxes. The states gave up their own power to declare war and said, we will trust us with the federal government. And by giving up their own power, they gave it up for themselves. Whatever powers they gave to the federal government, they no longer have. And this is what Article 1, Section 8 says. If a power was given from the states to the feds in Section 8, the states no longer have it. If there's a prohibition the states agree to in Section 10, the states can't do it. So to understand Article 1, Section 8 and all the powers there, we have to understand that these were powers the states voluntarily ceded and gave up to the new central government. And by giving it up, they can no longer exercise it, which explains the first case of Gibbons v. Ogden, right? The states gave up their power to regulate interstate commerce. Therefore, the states can no longer regulate interstate commerce. Now it makes sense, right? The states gave up their powers to tax. In McCulloch v. Maryland, right? They gave up their power. Then they can't tax the federal bank. All the powers that they gave up, they can no longer exercise. Everyone get that, right? This is the point that, I mean, his opinions are usually very good. This one's not very good, as I'm sure you're well aware, right? This is why I went through this entire historical summary, which explains his opinion in much more clarity. The powers the states gave up upon ratifying the Constitution were given to the federal government. And once the powers were embraced by the federal government, the states can no longer exercise those authorities. That the sovereignty of the states were diminished upon entering the Union. Not entirely, but whatever they gave up, they no longer had. Everyone get that much. We'll go through McCulloch in a minute. Not McCulloch, sorry, Gibbons in a minute. But I want you all to understand that principle. Any questions on that principle? That when you look at Article 1, Section 8, never forget those are powers that the states relinquished. And by relinquishing those powers, it became exclusively a province of the federal government to act. Okay, any questions on that? Are you scratching your head? You have a question? Okay. I try and look for motion. I see motion. I think something's up. All right. So I mentioned already the 9th Amendment. I want to discuss, I'm sorry, the 10th Amendment. I want to discuss the 9th Amendment for a moment because it's an amendment that most law students never even read. And if they read it, they don't understand it. Okay? So we look at the 9th Amendment. The 9th Amendment says, the enumeration of the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. So one of the big controversies over the framing of the Constitution was whether there would be a Bill of Rights, whether there would be a set of amendments guaranteeing rights. Believe it or not, this was a debate. A number of the framers did not want a Bill of Rights. Okay? A number of the framers did not want a Bill of Rights. Sean, why? I'm sorry, William. Why do you think a number of the framers of the Constitution did not want a Bill of Rights? Yeah, why would anyone be opposed to listing rights in the Constitution? Why would anyone be opposed to that? Oh. So everyone remember from contracts, the expressio unius canon. Did you say this? No. Okay. So I'll explain it myself. It's fine. What happens, Cash? Let's say you and I were drafting a new constitution, right? And we're awesome, right? And we say, okay, look, you have the right to free speech. You have the right to freedom of religion. You have the right to, keep and bear arms. You have the right to search and seizure. You have all these cool rights. And we write this amendment, and it's awesome, right? And then someone comes along and says, do I have the right to wear a hat? Do I have the right to wear a hat? Well, the Constitution says nothing about wearing a hat. Do I have the right to wear a hat? Well, what if the government passes a law banning hats? So you can't wear a hat. This is actually a real example, by the way. Government passed a law saying you cannot wear a hat on Sunday. I'll make it easy, right? You can't wear a hat on Sunday. I go, look, I have my Constitution here. And he's like, all right, where's the hat amendment? Where's the hat amendment? Cash, do you have a legal argument? I mean, this says something about hats. So you don't have a word. Well, Cash is right. I think Cash actually makes an astute point, right? Cash makes an astute point. It's impossible to enumerate all of our rights. It is impossible to enumerate all of our rights. It's not possible. It's not possible at all. The framers recognize this. So the original fear was if we list, 9 or 10 rights, then all the millions of other things which we value for individual freedom cannot be listed. We can't do it. So one of the first amendments proposed by James Madison, who wrote one of the original drafts of this, was the 9th Amendment. And what it says is the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. What does that mean? Well, it means exactly that. The mere fact that a right is not listed does not mean we don't have it. The mere fact that we don't have a hat amendment does not mean that I can be prohibited from wearing a hat, right? At its most basic structure, it's a rule of construction. What do I mean by that? It's how to read the Constitution. The mere fact that you have this right doesn't mean that other rights don't exist. Okay? Everyone get that much. That much is easy. No one disagrees about that part. The part that people disagree with, right, Alexa, is this phrase. Rights retained by the people. Rights retained by the people. So what are these rights retained by the people, Alexa? So what we have up there, does it include a hat? I'm sorry? It doesn't say. How are we supposed to know what these rights retained by the people are? Does it include, say, abortion, same-sex marriage, assisted suicide, a right to health care, a right to housing? What are these rights retained by the people? Natural. What the hell are these natural? What are these natural rights? What are these things? Where do I find them? And where? Louder? You said something. I couldn't hear it. That's all we have. The text up there. That's all you got. That's all it says. Does the Constitution refer back to the Declaration anywhere? It actually does, but it's a point of debate. I think it does, but there's a debate on this. What do you think, Morgan? I'll leave Alex alone. How do we understand this phrase "rights retained by the people"? Where do we? Louder, I can't hear. Okay, so does that include like abortion and sterilization and suicide and everything else? Who gets to decide what these rights are? That's your harder question. Who? Not what, but who. Who gets to decide what these rights are? The people. How do people get to decide what the rights are? By what mechanism? Voting, okay. Christine, ask it again. How do the people decide? I'm sorry. Who gets to, I answered my question incorrectly. Who gets to decide what these rights retained by the people are? Your colleagues said the people. Who else can decide? Well, let me ask you this question, Christine. Congress passed a law saying you cannot wear a hat. You wear a hat, you're arrested, and you're charged with wearing a hat. What's your defense? You're a constitutional lawyer. What's your defense? Oh, of course it was your hat, but the law says no hats. Doesn't matter who owns it. The law says no hats. What do you argue if you're a constitutional lawyer? In light of our discussion at the moment, maybe give you a hint. What are you going to say? No, we're even at the Ninth Amendment. No, we're discussing the Ninth Amendment. Make an argument with the Ninth Amendment regarding a hat. What's right are we talking about here? Yes, yes. Christine says, "I have the right to wear a hat, Your Honor, and it's protected by the Ninth Amendment." Okay, the federal law is unconstitutional. Okay, Delarum, you're a judge. How do you reply to that argument? I'm asking you. You're the judge. Christine just made this argument to you. You're the judge. What do you say? Louder. What? Right. All right. So you'll say that the right to wear a hat is among the rights retained by the people. Is that your ruling? Why?
Well, it doesn't do any harm. I mean, if no one is opposed to it.
Where do you get that from? What people told you this? You're a judge. Where are you making this rule from? Yeah, I mean, Sydney. I mean, you're a judge. How do you rule in this case? Do you rule that wearing a hat is protected by the Ninth Amendment? Okay. What's the basis of your opinion? I rack that. What's your A? Good. So how do you know? But how do you know that's among the rights that exist? Yeah. What do you think, Randall?
You want me to argue based on her?
You can argue whatever you want, or take the other position. We heard it two people.
I don't think that that's necessarily precluded by the.
So you think the right to wear a hat would be okay? A law banning hat wearing would be okay?
Yeah.
Why? Why is that not a right retained by the people? Why are your colleagues wrong?
So it may have been retained by the people, like based on the Bill of Rights, but that doesn't mean that the legislature can't come in later and determine whether or not that right should be retained.
Beautiful answer. Beautiful answer. So the lesson for this, yeah, get this pumped out, right? So the lesson for this one is this, right? The Constitution is silent about who gets to decide what the rights retained by the people are. Silence. I mean, I can argue either way. There are good arguments on both sides, but the text of the Constitution doesn't give the answer. So some people argue that judges are charged with deciding what natural rights are, to use your phrase, to use what these rights retained by the people are. That judges can identify what are called unenumerated rights. Rights are not written down. Others charge that, well, the legislature decides. The people decide what rights they have. And if Congress wants to pass a law saying you don't have a right to a hat, well then damn, they can pass a law saying you don't have a right to a hat. We will spend a lot of time on this topic of unenumerated rights. In fact, the entire discussion of the 14th Amendment, from abortion to same-sex marriage, everything in between, involves judges deciding that the Constitution protects certain rights which are not listed, which are not enumerated. And the same debate which we're having now will come back with a much more forceful topic in about 2 or 3 weeks. Okay, so any questions? Okay. Let's move on to Gibbons. I've already talked about it, but let's explain it, and I'll move through it a little bit quick because we've already done a lot of it. So the facts in Gibbon were this. New York granted a monopoly to Robert Fulton, who invented the steamboat, to traffic ships between New York and New Jersey. Okay. Unsurprisingly, one of the people involved with that business broke off. And with the expertise he gained, he decided to compete against his former boss. Nothing strange here. The only problem was New York prohibited Mr. Gibbons from docking a ferry service in New York. Okay. So, Felipe, obviously Mr. Gibbons didn't like this law, right? He didn't like this law. What then was his legal argument about why New York could not enact this law?
Go against the power of Congress to regulate commerce.
Yeah. What did Congress do in this case? What act did Congress enact? What law did Congress enact in this case? What was the law that New York enacted that was problematic here? What did it say? I already told you. What was the New York law? What did the New York law say? Let's start there. So New York granted monopoly to Fulton, right? To Ogden. Okay. What was the act of Congress, Felipe? What was the act of Congress that's relevant? What was the source of the conflict? Angela, you know? Oh, go ahead, Phil. If you have it, yeah, go for it.
Or the enactor enrolling in licensing.
Very good. So we have 2 statutes here, right? We have a New York statute that gives a monopoly to Ogden. We have a federal statute that authorizes Ogden to engage in navigation on the waters. Okay, so we have a state statute and we have a federal statute. Nancy, I'm sorry, I'm not saying Angela, are these in tension? Are these 2 laws in tension, the state law and the federal law? No, are they in tension? Are they? How are they? Sorry, how are they in tension?
Well, one is that the regulation of the commerce with the state sense that they can exercise this
Keep going. That's fine. Keep answering. You're right so far. What is the tension between the state and federal statute?
that will so Congress has their power to regulate interstate commerce. And
Good.
it's considered the interest of commerce because the water is part of commerce.
Okay, good. So here's the situation, right? The New York State legislature decided that only boats that they approve of can navigate in New York waters. Congress passed a law saying that if you register with Congress, you can navigate in any state. The conflict is this. How can you do both? If Congress gave you permission to navigate anywhere in American waters, and New York gave you permission to not navigate in New York waters, you can't do both. So this case wasn't the United States government saying, hey, New York, your law is unconstitutional. Okay? This case arose. Okay? This case, tell us outside. Can someone just tell him to be quiet, please? Rebecca? Yeah, thank you. Okay. So just don't shh. So what happened? Thanks, Rebecca. Thanks, guys. So what happened, right, is you had a New York law saying you can't do something, and you had a federal law saying you can do something. Ogden went to court and sued Gibbons. He said, wait a minute. These guys are violating New York law. Injunction, stop them from coming to New York harbors. So what did Gibbons say? Gibbons said, no, wait a minute. Your New York statute is unconstitutional. Look, I'm violating your New York statute, but your New York statute is unconstitutional because it's in conflict with a federal law. So there's a concept I want to discuss, right? It's called preemption. The book mentions it, but doesn't define it. Preemption is a conflict between a state and federal law. And this is a very complicated area of the law. But for the most part, when a state law conflicts with something that the federal government does, the state law is called preempted. Can you just tell them to move? Excuse me? Whitney, can you just tell them to stop talking? Tell them to go down the halls. Distracting. Thank you so much. Can you guys move? Just go somewhere else. Thank you. Just go, yeah, go to the stairs. Thank you. They don't listen. So you have this conflict, right? Now the better question is, why, when the states and federal government have a conflict, does the federal law prevail? Daniel, when there's a conflict between the state and the federal law, why does the federal law prevail?
Well, there is a need for national uniformity. If Congress is supposed to have foreign relations with other countries, it has to be between all of the states as a whole uniformly. It can't just be like, well, most of the states say the law is like this, and that's the law we're going to use to deal with this.
Okay, so let me ask the question like this. I asked this question 5 minutes ago. What powers does Congress have? Where did Congress get its powers from? Article 1. And where did Article 1 get its powers from? How did those powers get there?
The states gave them up.
Yes. The reason why New York cannot regulate navigation between the states is that they gave that power up. They relinquished the power to regulate interstate commerce, therefore they have no power to do so. So it's not that the federal statute trumps the states because the states are inferior. The states gave the government that power, and by giving up, they relinquished it. This is actually what preemption means. It's not simply one trumping the other, although that's an easy way of thinking about it. The states gave up their power to regulate interstate commerce. Therefore, it's a power that the federal government has solely. Everyone get that? Right? It's an insight most lawsuits will never understand. It's not just the federal government trumps the state governments. No, the states gave them that power. And once the states gave up that power, their police power is diminished. So imagine that. New York has this vast police power. However, absent from that police power is the power to regulate interstate commerce. Why is the power to regulate interstate commerce absent? Because they gave it up in 1787.
Were a lot of the people that were in charge of the states also signed the Constitution?
Yeah.
That seems like a lot of lack of self-interest, which is the basis of everything that we've been talking
How was the Constitution ratified, my friend?
by the 13 states. They all signed it.
Who signed it in the states?
The first
Oh,
the first
the
9.
conventions. Every state, each of the 13 states held a convention, not of elected representatives, but the people. The reason why we the people is such a powerful phrase is because it's actually the people of the states that relinquished their own sovereignty to this federal government. So no, in fact, to push back against your claim, they knowingly gave up these authorities to the central government. They knowingly did so. Because under the Articles, they didn't give up a lot of powers. They gave up very few powers. And it was a fragile, crappy government. Didn't work. But the Constitution said, you know what? We need to give up more of our police power, chop up our police power, and give some to the states. Let's give it from the states to the feds. Okay. Everyone get that much? So the general premise is, because the states relinquished this power to the federal government, they no longer have the power to regulate interstate commerce. And a boat going from one state to the next is interstate commerce. Right? Therefore, because New York had no power to authorize that law, the law is preempted. Everyone get that? Now that's the second part of Marshall's opinion. That's the part that is important. But the first part I want to dwell on, because he spends several minutes discussing the meaning of a few words in the Commerce Clause. The Commerce Clause is in Article 1, Section 8. And this is probably, next to the Necessary and Proper Clause, the most significant provision of the Article 1 by far. Okay? It's probably one of those significant provisions. Virtually everything that the federal government does today, with limited exceptions, is premised on Article 1, Section 8, Commerce Clause. This is where Congress has just about everything. And Marshall tries to figure out the meaning of three words: regulate, commerce, and among. And what Marshall does here significantly impacts the manner in which future courts would understand it. So the word commerce is hard to define. Even in 1787, there's articles on both sides about how to understand it. But Marshall defines it as intercourse. Get your minds out of the gutter. Intercourse means the exchange of different things, right? This is everything in why it's called intercourse, is exchanging going on. Think about it. There it is. You learn something new every day. It includes navigation. It includes business. It includes trade, right? Includes navigation. I said that already, right? Marshall defines commerce very broadly. It's not merely buying and selling stuff. It includes a sort of intercourse between the states. The second word he defines is among. Now, this is often called the Interstate Commerce Clause. The Interstate Commerce Clause. It's called interstate because the understanding is it applies when you go from one state to another, from New York to New Jersey, from Texas to Oklahoma. But Marshall doesn't read it like that. He says among means, quote, intermingled with. Among means intermingled with. What does that mean? Of course it includes commerce going from, say, New York to New Jersey. That's easy. But there are some acts of commerce that are intrastate, right? There are some acts of commerce that don't stop at the boundary line. So what if you're starting on a train, going from one state to the other, starts in New York, goes choo-choo-choo right to New Jersey? Can Congress not regulate the part of the train tracks that are still in New York? Can they only regulate the split second between the state borders, right? Marshall doesn't define this, but this phrase intermingled with, or more states than one, gives rise to the power of the federal government to regulate commerce that's really only in one state. But he doesn't define it quite that broadly yet. And the final word, regulate. What does regulate mean? Well, this is a word which is deeply understood in today's administrative state. But Marshall defines it as, quote, the rule by which commerce is to be governed. And this, Marshall says, is basically a broad power. Congress can basically do whatever it wants here. They can do whatever it wants. So long as there's something deemed commerce that's intermingled among the states, Congress can regulate it in any manner they see fit, and that regulation preempts or trumps any state regulation. Everyone get that? Right? The three contributions, the meaning of regulate, meaning of commerce, meaning of among. These opinions were not necessary to the case, but they will be cited decades and decades later in other cases. Okay. I'll get that. All right. Any questions on Gibbons? Yes, sir.
Do you think that his definition of among was correct?
No. But it's what prevailed. Yeah, I mean, I said this before. Marshall's wrong about a lot of things. And this was maybe one of them. But that's such as law. Other questions? All right, so for the remaining 20 minutes or so of class, and we're running a little bit short on time because I had to provide a history of Justice Scalia's legacy, I want to walk through the last 10 pages or so of your reading, which gives a history of Commerce Clause cases leading up to United States versus Darby. And the way I want to frame this issue is that the court was somewhat schizophrenic with the Commerce Clause. They adopted many different approaches to deciding what commerce means. These cases drive law students crazy because it varied and fluctuated back and forth in so many respects. This is not unique to the Commerce Clause. We'll do something called substantive due process later. Try figuring out the difference between Lawrence v. Texas and United States versus Windsor and a Bergefall. I'll give you a medal, right? But there are many instances where the court, jumps around. And these are cases decided over the course of about 30 or 40 years, so you also have different justices who view things differently. But here the court was attempting to grapple with different approaches of what commerce is. And the reason why this became relevant is at the turn of the 20th century, Congress started to need to, or Congress felt the need to regulate increasing sectors of the economy. We had these new things called trains, which made it impossible to go from one end of the country to another in a couple weeks. We had these new things called telegraphs, which made it possible to instantly conduct business across the country. We had these new things called cars, right, that made it possible to travel distances. Our country got a lot smaller, even though the size was the same. And Congress felt the need to standardize various aspects of commercial activity among the states. But with this tension, the Supreme Court, in various respects, resisted it, saying that Congress cannot regulate commerce only within one state. They can only regulate commerce between the states or among. So the history here, I think, will be a little bit difficult to follow. But let me lecture for a bit. So the first case from 1895, called United States versus E.C. Knight. Okay. United States versus E.C. Knight. This involved a sugar monopoly, where effectively one company bought a monopoly power and had 98% of the sugar refining power. Congress had passed a law prohibiting a monopoly for manufacturing, right? For manufacturing. The question then became, was manufacturing commerce? Right? John Marshall says, like trade and navigation, was making sugar a commerce. The court in a 5-4 decision said no. Manufacturing was not commerce. Okay? Manufacturing was not commerce. The court wrote that if Congress includes the power to regulate manufacturing, they could regulate everything. Because what's manufacture? Manufacture is creating stuff. If Congress can regulate manufacture, they can regulate anything. And they wrote that this would violate the 10th Amendment. Why? Because the states have creation And if the federal government says they have this power, that supplants the state's power. Let's say it again. If the feds have this power to regulate manufacture, that means that power is taken away from the states. And this, the court said, is not consistent with the 10th Amendment. Okay. Any questions on EC Knight? Okay. The next case to discuss is 1903. It's called Champion v. Ames, or the lottery case. I'll explain why in a minute. It was 1903. Okay. This case retreated from Champion. I'm sorry. This case retreated from EC Knight. EC Knight was very restrictive. Champion v. Ames was very broad. And it involved the shipment of lottery tickets. That's why it's called the lottery case. It involved the shipment of lottery tickets from Texas to California. Congress had passed a law criminalizing the shipment of lottery tickets among state lines. So the question became one of this: are lottery tickets commerce? Right? Are lottery tickets commerce? So the court doesn't answer that question. Instead, what they say is that Congress can regulate the, quote, channels of commerce. The channels of commerce, that is the roads, the highways, the railroads. Okay? Congress can regulate these channels of commerce. So even though these lottery tickets are immoral goods, which is fine, Congress can regulate the fact that they're moving across state lines, even if the item itself is not commerce. So imagine that. Manufacturing sugar is not commerce. Shipping lottery tickets is commerce. If this is confusing you, hang on for the ride. Okay. Any questions on the lottery ticket case? Okay, we move forward to 1914. It's called the Shreveport rate case. And if any of you know where Shreveport is, it's from Louisiana, also involving Texas. So a federal agency known as the ICC, the Interstate Commerce Commission, this was the first true federal agency. The ICC, okay, decided they want to regulate railroad rates. They found that Louisiana was charging people too much. So if you wanted to go within Louisiana, it was very expensive. But to go from Louisiana to Texas was cheap. So the ICC said, we're going to set standardized rates for you to use. When the railroad said, wait a minute, this is a train route entirely within the state of Louisiana. We never cross state lines with these trains. How can you regulate this? Okay? And the court said, right, that Congress cannot regulate commerce within one state, but they can protect interstate commerce. They can protect what are called the instrumentalities of commerce, like the railroad tracks. Okay? In order to make an effective interstate market on the railroads, they can't have people charging these unfair rates. So how do you reconcile that, right? Congress can't regulate sugar, but they can regulate lottery tickets, and they can regulate railroads. Any questions on the rate case? Okay, we keep going. Again, I run through these quickly because they're somewhat all over the place. We have Caminetti, which is from 1917. This is often called the Human Trafficking or the White Slave Traffic Act, effectively prostitution. So what happens is you'd have a guy, if I remember correctly, was bringing prostitutes from California to Nevada, right? Always Nevada. What happens in Vegas? Never mind. Can Congress regulate the importation of persons, right? And there's actually an interesting historical pedigree because we actually have provisions of the Constitution regulating the importation of persons. But here, the argument was that the trafficking of prostitutes was commerce. Okay? So the court said, look, okay, we understand that prostitutes are not commercial activity. They may engage in commercial activities, but they themselves are not commercial. But you can keep these interstate channels open. And they said because using interstate roads, well, that's something that Congress can regulate. So again, that was 1917. We're going all over the place. We move forward to where things change. This is the biggie. Hammer versus Dagenhart, 1918. This is a very significant case. So Congress passed a law that banned the shipment of goods made with child labor. They passed a law that banned goods made with child labor. Note, they did not ban the manufacturing of child labor goods. They couldn't, because under E.C. Knight, manufacturing is not commerce. Instead, they said, okay, we won't ban you from making child labor. We'll simply ban you from using the instrumentalities to ship it. Sounds good, right? If you want to ship child labor goods outside the state, you can't do it under this federal law. The court invalidated that statute. The court invalidated that statute. They said Congress cannot regulate the manner in which goods are created. Okay? Even though, right, this law didn't mention manufacturing, it was targeted at prohibiting child labor. And this, the court said, could not be done. Regulation of labor was purely a matter of state law under the 10th Amendment and the police power. And this was not for the feds to do. Okay? The states could regulate labor, not the federal government. This case was overruled by Darby later, which we'll get to in about 3 minutes. It continues. 1922, child labor tax case, which is also called Bailey v. Drexel Furniture. What happened? Congress got smart. They said, okay, wait a minute. We can't ban the shipment of child labor goods. So what we're going to do? We're going to tax it. We're going to impose a 10% tax on all of the profits made from goods with child labor. 10% tax. Now, I don't know if you've ever guys have been in business, but a 10% tax on your profits basically takes away all of your profits. This was a very, very, very clear effort to put out of business child labor manufacturers. Very clear effort. There was no doubt here what this was trying to do. They were trying to do what the court said could not be done in Hammer. They can't touch this, right? They were trying to do what they said could not be done in Hammer. They're trying to get around it. Fire rolls in that. All right. So the court said, no. This is not really a tax. Pay attention to this one. The court said, this is not really a tax. You're basically calling something a tax when it's actually a regulation, because no one can afford to pay this tax. This was simply put out of business. You are accomplishing through the taxing power what you cannot do through the commerce power. Therefore, this is unconstitutional. Keep this in mind. We'll be discussing the Obamacare case in a couple weeks. For decades, law students were taught this case was overturned, that this case was irrelevant. It was really relevant. Because in the Obamacare case, the court did the opposite. It said, even though you didn't call it a tax, we will treat it as a tax. Okay. We move along. Any other questions on Bailey? I got like 3 or 4 more cases. I'm almost done, then we can talk. Next case, ALA Schechter Poultry Corp. Schechter, I'm going to spell it wrong. Poultry Corp, United States, 1935. This is often called the sick chicken case. Okay, the reason why it's called a sick chicken case is because the Roosevelt administration enacted something called the NRA. No, not the National Rifle Association. The National Industrial Recovery Act, which was meant to help our nation recover and help our nation get out of the Depression. Had the exact opposite effect. It prolonged the Depression, but that's neither here nor there. So one of the aspects of the NIRA was to promote rules of competition, or codes of fair competition, where they basically told every business how to run their business. You have to have chickens of this size, of this weight, and anything else is illegal. Okay? Butchers in the 1930s were not so standardized. In fact, this was a kosher butcher in Brooklyn called the Schechter brothers, and they ran a kosher butcher which was incompatible with the rules of the Roosevelt administration. It's a religious component as well. So what happened? They imposed all these restrictions, and it was impossible to comply. They brought suit. And the court said first, this was a unanimous decision against Roosevelt, that the Congress cannot delegate, right? They cannot delegate to the president the power to make these laws. Effectively, the president was empowered to make laws of how commerce should be conducted. It was a non-delegation case. We'll come back to that later. But the more important holding was that chickens in a state was not interstate commerce, right? A single chicken in a cage in Brooklyn, chickens cannot fly away. It is not interstate commerce. Okay. We got a few more cases. We're almost there. 1936, Carter versus Carter Coal. 1936. This was a question about whether Congress could regulate coal mining. The court said that coal mining is not commerce, it is production. Coal mining is not commerce, it is production. Therefore, Congress cannot regulate the coal mining industry. Okay, everyone with me so far? I know that was fast. This is in your book, so you can go back and fill it in again. But I want you to understand these cases. Then something crazy happens. 1936 is a inflection point in our history. Franklin Roosevelt had just won a landslide election, re-elected president. And he announced a plan. Okay? He said, listen, the Supreme Court, they're not with the times. They're not with it. The justices are striking down all of my programs. They're striking down my labor bill. They're striking down my coal bill. They're striking down my sick chicken bill, right? They're striking everything down. We need to do something about this. We need to do something. So Roosevelt proposed what became known as the court packing plan. The court packing plan, okay? I'll probably go about 3 or 4 minutes over, so please just stick around. Don't start packing up. The court packing plan. The purpose of the court packing plan was to add a new justice for every justice over the age of 70. So they added roughly 6 new justices. Oh, by the way, all the old ones were Republican-appointed judges. So lest anyone think that trying to fuss with the Supreme Court is a new invention, this has been going on for a long time. Lest anyone think that presidents try to appoint judges that fit their ideology, there's new. No, it's going on for a while. So Roosevelt threatened to basically moot the Supreme Court and to appoint 6 new justices. Exactly what happened isn't clear, but starting in 1937, there was a switch. The famous switch in time that saved 9. The switch in time that saved the 9 justices. And a justice by the name of Roberts, appropriately enough, Owen Roberts, not John, but Owen Roberts, changed his vote in a number of key cases involving progressive legislation. Where in the past he was some of a moderate conservative, he changed his vote to uphold these new laws. Now, whether he was actually influenced by the court packing plan or not is subject to vast debate. But the timing of this is such that at the exact moment when Roosevelt was proposing these amendments, or these court packing plan, the justice decided to uphold his programs. So after 1936, it was smooth sailing for FDR. And I want to give you one quote. One of Roosevelt's top attorneys, a guy named Rexford Tugwell, acknowledged, now I'll read you a quote, that squaring the New Deal with the Constitution requires, quote, tortured interpretations of a document intended to prevent them. Roosevelt understood that, however inconsistent the court's precedents were, what he was trying to do was inconsistent with the Constitution. He considered amending the Constitution, but found it much easier to play with the Supreme Court. He considered amending the Constitution, but it would be a lot easier to appoint a couple new justices. And it worked. We will discuss this point of 1936 a lot more. Just don't back up. We have another 3-4 minutes. So then it changes with a case in 1937 called National Labor Relations Board versus Jones and Laughlin Steel. 1937, right? This is after this 1936 inflection point. Now, I always say for the exam, different time periods to ask about. This is a good period for me to ask you guys about. Okay, it's a good period for me to ask you about. 1937, Jones and Laughlin Steel. This law was a National Labor Relations Act. It regulated all manner of relations between unions and industry. It forced industry to negotiate with the unions and then gave the unions a monopoly on negotiation. Never thought about that, but unions are monopolies, right? If you want to negotiate, there's only one entity to go to. So basically, unions were exempted from monopoly laws and required to negotiate with companies. Okay? Now, is a labor negotiation in one state interstate commerce under the old definitions? No. But the court overturns all those old cases. In a decision by Chief Justice Charles Evan Hughes, probably one of the most significant decisions of the 20th century, the court rejected this idea of direct versus indirect effects on interstate commerce. They got rid of this idea of production or manufacture. They said so long as an activity has, quote, a close and substantial relationship to interstate commerce, if it has a close and substantial relationship to interstate commerce, Congress can regulate it. This overturns a lot of other cases that held otherwise. There was no attempt to reconcile this with the past. It simply said those cases were wrong. We no longer adhere to them. And then several years later, I think it was in 41, you have the case in your book, U.S. v. Darby. 1941. Okay. This is considered a minimum wage law. It's considered a minimum wage law that prohibited people from shipping any goods in interstate commerce unless the workers were paid a federal minimum wage. Is the wage itself commerce? The old definition? No. But the court effectively says that, look, it's not manufacturing we're talking about, but it's commerce. And citing Gibbons v. Ogden, they effectively say that commerce includes regulations about wages. This is a comprehensive scheme about how stuff is made. Citing John Marshall, it's commerce enough. It's intercourse. What about the 10th Amendment? The fact that it is invading state powers and it's intruding upon the state's prerogative. The court says, doesn't matter. The 10th Amendment is but a truism, it says. It's but a truism. What does that mean? It doesn't actually give any powers to the states. All it says is powers not given to the states. Powers not given to Congress are retained by the states. What are these old opinions? Well, they overrule Hammer. They overrule everything else. In fact, they really rely on Gibbons significantly. The 10th Amendment says nothing to the contrary. And we will discuss the evolution of the Commerce Clause doctrine more next week. But the lesson I want you guys to take home is 36 was a major changing point, a turning point in our law. And it radically altered the balance between the federal government and the state government. And it wasn't until the 1980s, and a guy named Scalia hopped on the court, really, that federalism and the separation of powers began once again to have a prominent role in the Supreme Court. Questions? Thank you for staying late. I don't like doing this, but today was late. So I will see all of you on Tuesday. Thank you.